Hi, John Bryan, West Virginia civil rights lawyer here. Let me tell you about this video that I saw today that took place in San Angelo, Texas, in a Walmart. And it really struck me in a number of ways, and I'll explain that to you, but here's the video.
They said he possibly had a child with him too, so.
Do you have a description at all, sir?
Just said that he had brown curly hair. That was it. Unknown description.
Eyewitness account.
Nobody in the store has anything on him. They don't know who he is, but nobody in the store has seen him or even know what he really looks like. There's all the
guy with like a 3-year-old in there.
I'll go back in.
Basically what happened here is somebody had called the cops and said that there was this drunk guy outside of Walmart, and there was really no connection between that call and the guy they ended up encountering inside Walmart, except maybe, I don't know, something. I'll let you speculate on why they actually singled this guy out. Or maybe it was Walmart.
Excuse me. Hey man, can I talk to you for a minute? Y'all can go on through. Have you been talking to anybody around here?
Talking to.
Oh, we've got calls that someone's out here harassing people, and they may be drunk. You haven't had anything to drink tonight? Nothing like that? Nothing?
You blowing your face?
No, I'm good.
Yeah, I didn't think so.
Well, they said that someone. What kind of vehicle do you drive?
Equinox?
Equinox. So you haven't had anything to drink today, anything like that? You just getting off work or something?
No. Left home, came to the grocery store.
Okay.
What's your name, bud? Huh? What's your name? Jack. Huh? Jack? Jack?
Jack what? Yeah, it does.
Note that the first question here is whether the Fourth Amendment is triggered. So at first, this is a consensual encounter. Consensual encounters do not trigger the Fourth Amendment. And that's why many people ask, am I free to leave? Just like anybody, a police officer can walk up to somebody and they can ask them questions, ask them their name, ask them what kind of car they drive, and the Fourth Amendment is not necessarily triggered. At some point, the Fourth Amendment can be triggered. And that's when you go from a consensual encounter to you have what would be here an investigative detention. So as a general matter, police officers are free to approach and question individuals, but at some point, there will be a seizure within the meaning of the Fourth Amendment, quoting Terry versus Ohio. And that occurs when, after considering the totality of the circumstances, remember, it's always a factual analysis, whether a reasonable person would believe that they're free to leave or whether they're not free to leave. At that point, if a reasonable person would not feel that they're free to terminate the encounter, then the Fourth Amendment is triggered. You have an investigatory detention. And of course, if they tell them they're not free to leave, you have an investigatory detention. It's not as great as a use of force situation yet, but it does trigger the Fourth Amendment. And what does that mean? It means that reasonable suspicion is required. And so I'll play the video a little more and we'll see if we get to that point and if there's any reasonable suspicion.
I do, but I don't have to get an ID.
I don't think you understand what this is. This is not, you get to tell us what is what. So,
What's your name? And you're saying I have to give
Look,
my name just because?
look, we're not trying to hand you up or anything. We're trying to make sense of what's going on because someone's telling us that someone is possibly driving drunk with a child in the car. They gave us your vehicle and a description of you.
Do you have a description at all, sir?
Just said that he had brown curly hair. That was it. Unknown description.
Eyewitness account.
They gave us your vehicle and a description of you.
Okay.
So, I mean, you can either make this long, drawn out, and difficult and keep your son out
Well,
here
you can
with all your
see-
groceries. See
You
what?
can see that I'm not drunk, right?
I don't know that. You mean all you did is tell me that?
Well, okay, after?
Okay, well, we're trying to verify who you are, and you're making that difficult. It's not that hard to just hand over an ID.
It's not that hard for me to go about my day without even drinking or doing anything, but I mean, tell me I'm forced to ID myself. That's bullshit.
Well, you're. Do you have any ID on you?
I do have an ID on me.
May I please see your ID? Just to verify who you are.
What
Simple
good
as
is it
that.
going to do?
A lot of times,
What good is it going to do is verify who I am?
because sometimes people want to tell us to treat it like level.
So, it's well established that even a temporary detention of an individual where they're not free to leave, no matter how short of a time or no matter for how limited of a purpose, it triggers the Fourth Amendment and it's a seizure nonetheless. So, what is required before that can happen? There must be reasonable suspicion. And what is reasonable suspicion? The actual case law says that it's a common sense, non technical standard that relies on what the objective, experienced police officer would be able to articulate under the circumstances. So it's not this bumbling younger guy that clearly doesn't know what he's doing. It's supposed to be, maybe a supervisor type or somebody who's been doing it a long time. But there has to be, somebody like that has to be able to logically demonstrate and articulate, given the facts surrounding the situation, that there's some behavior that's likely to be indicative of some more sinister activity that may appear at first glance. So there has to be some particularized fact scenario that applies to this actual person that they're seeking to detain. That has to be or should be based on illegal conduct. There are some cases that hold that there can be an amalgamation of innocuously innocent facts that combined together can make this evil mastermind potentially. But usually there has to be some suspicion of illegal conduct that's particular to this person.
Okay? So simply, I want to verify who you are. We'll go about your day. We'll go about our day, and we'll be done. That easy, that simple, man. My part is explain everything to you. Okay.
And y'all want to ID me.
You refusing to ID? Yes. Okay, but this is an intoxicated subject call.
Okay.
So this is what's probably going to happen. If it hasn't been explained to you already. Unless you identify yourself for this legal investigation, you're going to be arrested for failure to ID. Listen to me.
They see you?
And then we're going to call CPS to come pick up the kid.
Okay, so now you're threatening to take my kid.
What's your ID?
You're threatening to take my kid.
What's your identification? What's your name, dude?
Can I talk? I mean, y'all work
You
for
have
me. I
one
don't
thing
work
to
for y'all.
respond with right now, and that's to identify yourself.
And you can't.
So at the point he's threatened with arrest for not providing his ID, that clearly is a trigger for the Fourth Amendment. It's no longer a consensual encounter. It is an investigative detention, so there has to be reasonable suspicion. But there still has to be probable cause for there to be any arrest or even for there to be possibly a search of him. Now, the Supreme Court has a lot of cases on third-party tips to police, and clearly here they didn't really know anything. It was just sort of an anonymous tip, a 911 call. Specifically, the cases say that you have to look at the totality of the circumstances in the case. And here, the totality of the circumstances do not favor the police. The Florida versus JL case in 2000, the U.S. Supreme Court held that a police officer may not stop and frisk someone based solely on an anonymous tip that described the person's location and appearance but contained no details about any illegal conduct in which the person was participating or had participated. So there has to be a indicia of reliability. It doesn't have to be personally observed by law enforcement, but there has to be really some indicia of reliability or some corroboration based on what they see. And this just is a train wreck here, and it gets worse.
Failure to identify is whenever you have been lawfully arrested.
You just arrested. Go ahead. Turn around.
My kid is right there.
Turn around. Put your hands behind your back.
Look what you're doing, man. Baby, it's okay. Ow! What are you doing?
You're being placed under arrest for failed to ID. You got one resisting.
Baby, it's okay, baby.
We got him in custody.
Dumbass. What the hell are y'all doing?
Calm down.
Calm down. What are y'all doing? Oh. Somebody record this shit?
We're recording it right now.
So at this point, they've jumped ahead a couple steps, and now they've used force on the guy. They've taken him into custody. So what do they need now? Really, now they need probable cause. Now, probable cause is required to make a warrantless arrest of a guy in Walmart. It just is. Now, what is probable cause? It's when the facts and circumstances within the officer's knowledge are sufficient to warrant a prudent person or one of reasonable caution in believing in the circumstances shown that the suspect is committed or is committing or is about to commit a criminal offense. That's Michigan versus D. Filippo Scotus, 1979. Now, they don't have to always be correct factually, but they still have to possess reasonable grounds for arresting the person. And here, and as you'll see, they really have no reasonable grounds to arrest a guy in Walmart for not showing them an ID, which is not required by him under the law.
Yeah,
I lost my camera.
Recordings never help out.
It's down right there.
Y'all
Y'all got him?
got
Okay.
Okay, so you ID yourself? I just told you.
Hey, quit pushing back. He's fine.
A little late for that, isn't it? Under duress, now it sure is. What's your identification? Now you did anything wrong. You're under arrest, man. For what? We already told you. Failure to identify. Not very bright, are you? 3802. Penal code 3802. You can't be arrested unless you fail to identify or give false information after being lawfully arrested. Yeah. So, Daniel?
So not only do we have just a regular search and seizure Fourth Amendment violation here, at this point now we also have, in my opinion, an excessive force violation, but that's also Fourth Amendment. Now you can see that they did use force against the guy. The video speaks for itself. Now, did they give him a black eye? Did they break his nose? No. But it's all about the facts of the case and being reasonable. If they're unreasonable, they use unnecessary force, then we can prove an excessive force case here. So you have several violations that have occurred. Now remember the importance of video footage. Scott versus Harris, 2007 U.S. Supreme Court case. It says that when opposing parties tell two different stories, one of which is blatantly contradicted by video evidence contained in the record, a court should not adopt the version of the facts of the cops that are on the stand lying about. The court should adopt the version of the facts that are shown in the video, because video is the strongest evidence, way stronger than unreliable direct witness testimony.
You acting a fool. What are y'all doing?
I got ID.
Okay. You got warrants, bud? Is that the issue?
Just gonna walk him out.
Okay, baby. Walk me, please.
Not right now.
By the way, guess what? Guess who can't claim qualified immunity as defense? Walmart. That's right. Screw Walmart for what they did here. And I just happened to have had a conversation today about getting my own Walmart video from something that happened here in West Virginia. But that'll be for a different video soon. Let's continue. They take him outside, put him in the police car, and then something really interesting happens. This is the supervisor who walks up now. Listen carefully.
He was arriving and being placed under arrest.
So basically, these guys, the cops that were involved, are telling the supervisor what happened. And then you're going to hear the supervisor's response.
So, are there any use of force that needs to be reported to the police?
You have to pin him up against the little cooler deal to get him cuffed on.
So he asked whether there were any use of force situations. They don't really quite tell the truth. Yeah, they did use force, and Mr. Supervisor, you might want to watch back that body cam video.
I mean, no team takedowns or like that.
Okay, so the supervisor's on scene. They've told the supervisor what happened, all the information they had against the guy, the evidence they had against the guy, and you can just see the supervisor's like, oh, okay. And they lied about the use of force, so he didn't even know about that yet. And he's like, all right, well, here's what you're going to have to do. Take a listen to this.
All right. Release him. Okay. Explain to him that there was a mistake in the understanding of the law.
Okay.
And that he's free to go. However, it is best when asked by a police officer who he is, give his name. Even though it's not required, it's always best to just give your name if you've been told you've been lawfully detained. Okay? Do an information report, possibly witness information report, explaining the actions that were taken. But as far as that goes, he's up with 37. All right. Cool.
So here's what you got to do. Go release him and explain to him that it was a misunderstanding of the law. But it's really a good idea to give your ID to a police officer when they ask you. That reminds me of another video that I have. It was phrased in a much different way. By God, when a police officer tells you give your ID, you you do it. You do it.
What car?
We don't know who it was that someone called it in. And when we get these off, and I'm going to explain everything to you.
You can go that way, that's fine.
Let's see your wrist, please. Relax. I'm not going to hurt you. I'm not going to slam you. Okay? Just let me look at your wrist. Okay? That's all I'm doing. Turn your hand. Is yours or mine?
They're mine.
Yours. All right. Miss Miller, after talking with our sergeant, you got your stuff, by the way. You've had a misunderstanding and interpretation of the law.
That's right.
Okay.
It's the motherfucking Eagle Double G.
Snoop Dogg! You let me finish, please.
I need to get back to my son.
Okay, your son is fixing to come out of my office.
Okay, well,
What's going to happen is that
is there anything I have to do from here on?
no, I was going to let you know there's going to be a report and document everything, sir. You're free to go.
Did you get your camera?
Thank you.
Thank you.
For everything you did.
Yes, ma'am.
So there it is. By the way, he added that to his own video, but it was awesome. And it's always nice to have a happy ending. I hope that there's a happier ending with a nice lawsuit with some really exciting depositions and a great settlement at the end. And I wish I could handle that case, but I'm not in Texas. But that's a great case. And my favorite thing about it is that he didn't even go out looking to cause some sort of a problem or invite a problem. It just came to him. Literally, he's with his toddler trying to buy some soda, minding his own business. And you know what? Again, screw Walmart. And they came up there at the end and said, "Oh, thank you for your service, officer. Thank you so much for what you do." I mean, what? Why are they not liable for kidnapping his kid during that encounter? I hope he sues the hell out of Walmart for that. Of course, that's just my opinion.